State versus Damian Leisman, 20 CR 165.
Yes, sir.
Okay, you're in court. Let me see what we got here. It's a motion to revoke probation has been filed in this case. You have the right to have an attorney represent you in this matter. If you can't afford to hire an attorney, I'll appoint one. Do you know what you're trying to do with regard to an attorney?
No attorney, sir.
Alrighty. Somebody give him a waiver form then.
But
You have the right to hire your own attorney. Like I said, if you can't afford to hire one will be appointed, no cost up front to you. If you choose to represent yourself, you have to follow the rules of evidence and procedure just as if you're an attorney. There's no special treatment. Are you going to influence any alcohol or drugs right now?
no, sir.
Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. If you've reviewed the form and want to waive it and proceed today, representing yourself, you can sign it at this time.
Welcome back, everyone, and buckle up, because this one's a crash course in what not to do when facing a judge. Today, we're diving into the case of State versus Damian Leisman, a textbook example of how overconfidence in court can turn a simple probation hearing into a 6-month stay behind bars. Now, this isn't your typical sovereign citizen meltdown. This is something more subtle, and in many ways more tragic. It's the story of a man who thought he could navigate the judicial system solo. No attorney, no preparation, and no plan. Just faith that he could explain himself
to an attorney. I'll accept that waiver. I'll allow you to represent yourself. You understand you have the right to contest the allegations. Do you have a copy of the allegations, by the way?
No, sir. On the probation violation?
Yeah.
I believe it was for the remaining payment of the probation, because that was
I also failed to provide proof of obtaining drug and alcohol evaluation. Those were the allegations.
to do which one?
We'll bring you
The drug and alcohol evaluation?
Yes.
Okay. Alrighty. I did not do that unless I had done it with and sent it to Chris before, but yes, sir.
All right. Well, we're going to bring you a copy of those allegations here. All right. You understand? You have a copy of those in front of you, the affidavit alleging the violations?
No, it was the wrong paper. He's grabbing it right now. But I understand, sir. I do believe that I had forgotten the last time I talked with Chris, I do believe he had said that, and I had forgot about it and just thought it was payment.
And there it is, the fatal decision. The defendant just waived his right to an attorney, thinking he can go toe-to-toe with a judge in a probation violation hearing. Let's pause here. Representing yourself might sound empowering, but in a courtroom, it's like walking into a boxing match with a blindfold on. You're not just arguing feelings. You're navigating law, precedent, and evidence. The judge is even giving him a warning. The fool who represents himself has a fool for a client. That's not sarcasm. That's legal wisdom wrapped in a reality check. What's tragic is that this defendant doesn't seem to grasp how much danger he...
To establish a violation by a preponderance of the evidence, you have the right to present testimony of witnesses and other evidence on your behalf if you want to. If a probation violation is established or admitted to by you, I can continue, extend, modify, or revoke your probation. I could require you to serve the underlying sentence. You understand all the possible consequences?
Yes, sir.
Do you understand all your rights as I've explained them?
Yes, sir.
All right. It's alleged that you failed to make payments as required on your court costs, fines, as ordered by the court, and that your last payment was back on November 5th of 2021, and now you have still have a balance of $418 to that allegation. Do you admit or deny?
That I paid that up in full. Whenever I paid that, I believe it was this last week or the week before, and then scheduled for the court date for today.
Is it paid up?
The prior, I had made made arrangements. My mom had come over and to the court and paid everything remaining because I had moved down to South Texas, and then but they had added more charges, and then but the drug evaluation part, that I had forgotten all about that. but there's no record of.
Here's the turning point. He's admitting that he didn't complete his drug and alcohol evaluation, one of the key conditions of his probation. Now, for context, this evaluation isn't optional. It's not a suggestion. It's a court order meant to ensure rehabilitation and accountability, be why admitting to skipping it. He's practically handing the judge a reason to revoke probation. Notice how calm the judge remains, professional, measured, but his patience is fading. This is the kind of quiet tension that defines real courtroom drama. No shouting, no theatrics, just a slow-motion self-destruction in front of the bench.
So you're saying your mom paid off your fines or whatever? It's paid off?
And originally she had come up here to pay them. She paid everything they had on file, and then they had added that last $418 after she had come here to pay.
So the balance is $418 still. Is that correct?
No, that was paid last week or the week before.
Can somebody just go look?
We don't know.
We have no way of looking now. So let's skip that because
She said if it went to collections and he paid collections, we haven't been able to get it from them.
it may have went to collections. Let's just skip over to the next one. It's alleged you failed to provide proof of obtaining a drug and alcohol evaluation as ordered by the court. To that allegation, do you admit or deny?
I admit I did not do that.
Okay. I'll find that you, Mr. Marcinski, right now the court has no way of checking into any of this. I think it's been sent to collections is what I'm being told. So they don't know what's been paid, what hasn't been paid.
And if he has a receipt.
Yeah. Okay. Are you fine with skipping over the payment, Mr. Marcinski, at this point?
Well,
I'm not going to have a way of finding on it one way or another anyway, Miss, what I'm telling you. Nobody knows.
It appears to me that he is stipulating as of the date of this affidavit, he had not paid it. So the fact that he paid it 2 days ago or a week ago doesn't alleviate the fact that he committed this violation.
Well, that's okay.
I'm not going to contest that he hasn't paid as of today, but it would seem to me that as of the time of this PV affidavit, that amount was still
it's all academic. I don't put people in jail for not paying their fines usually anyway. So
now we hit the classic. It was paid, I think, defense. The problem? Courts deal in documentation, not memory. Saying my mom paid it last week without receipts or proof doesn't hold water. And to make it worse, the payment confusion distracts from the bigger issue, the missed evaluation. The judge and prosecutor are trying to piece together whether the fines were cleared, but the takeaway is clear. Organization matters in court. When you represent yourself, you become your own attorney, clerk, and paralegal. And if you don't have your paperwork straight, you've already lost half the battle.
I'll find that you've knowingly, willingly waived your rights. I'll accept your stipulation as to the second violation. I'll take the first one under advisement until stuff can be sorted out. I'm just not going to get into that right now. It's not really necessary. State's recommendation.
Judge, I may defer to Chris on this one. Looking at my file, we're a little light. All I see in here, my last notes in this file were when I offered Mr. Leesman a plea from the felonies that Kerwin had charged him with to a misdemeanor. The very next thing I have is the PV affidavit, and then my most recent document in the file shows a no bond warrant for his arrest. So obviously that at some point was lifted because he's bonded out and sitting in front of us.
I don't think so. He had us put on the docket and showed up. I think the warrant's still outstanding is what I'm told.
Okay.
As far as we know. So
I would probably ask Chris what he thinks is appropriate at this point. If the case is paid in full, you know, my primary cause for doing what I do is to try to get these folks into drug and alcohol treatment to help them get over their addictions. And it sounds like even as of today, that hasn't occurred in this particular case. And I see now that 3 years, almost 4 years later, I don't know what the benefit of that is, but there has to be some consequence to the violation. I mean, pretty much just disregarding of the probation. So I think at this point, Your Honor, I would probably request a sanction and then for the case to be terminated if it has indeed been paid in full, which I'm not contesting based on his statement that it has been paid. I would also ask the court to maybe ask Chris Hollis what he thinks is appropriate, at least as far as the sanction, and he may be able to even educate us about the payments and other things.
Your Honor, Mr. Leesman was on probation for almost a year, and he was on call-in reporting because he was a resident of Texas. Last time I spoke with him was on February 8th of 2022. and I informed him that he needed to come to Kansas so he can sign an extension of his probation due to the fact that he had not completed his drug and alcohol evaluation, and he didn't make, well, he still had an outstanding balance of $418. He told me that he's not going to make the time to come to Kansas, and that if I need to file an affidavit, then just go ahead and do it. And then, of course, we haven't heard from him in over a year, almost 2 years. So my recommendation is that his probation is revoked.
All right. Mr.
And
Lee,
when he did call in, Your Honor,
okay.
it was very sporadic. He would miss call in, report in. I'd have to call him, try and track him down. So he wasn't even really good at even that.
This is a fascinating moment. The judge says he doesn't jail people for unpaid fines, showing that despite his strict tone, he's fair. But fairness has limits. He's basically saying, I won't jail you for being broke, but I will for being careless. The message here? Judges care about effort. They know when someone's trying versus when they're dodging responsibility. If Damon had shown initiative, even a late effort to complete the evaluation, this outcome might have been salvageable. Instead, his attitude reads as passive, even indifferent. And in court, apathy is fatal. This is where everything collapses. The probation officer just confirmed the defendant ignored calls, missed reports, and refused to travel for paperwork. The prosecutor's tone shifts. No more flexibility, no more patience. The entire courtroom now sees a man who simply didn't care. And remember, this isn't about a violent crime. It's about compliance. The system gave him every chance to succeed outside of jail, but he treated probation like an optional chore. The tragedy is that he's realizing the stakes too late. This is the moment where representing himself goes from risky to...
I do apologize for the forgetting of that. I'd gotten in another accident right around that time before. It was October it was October before that February. I had talked to him, so I'd been healing up, and I forgot about that drug and alcohol evaluation. And whenever we had talked, I had asked, he said I had to be here tomorrow to sign the paper. And I was asking, because I couldn't come from Port Aransas at that time all the way to Kansas to sign a paper. And I was seeing if we could do it like over like fax or, over like e-documents. So I didn't have to come in person all the way to Kansas to extend it for me to go do that drug and alcohol evaluation. But I do apologize for forgetting about that part. And I could get one done as like today, as soon as we leave here. I just wanted to get this warrant taken care of, but I understand.
You can feel the desperation now. He's apologizing, explaining the accident, offering complete the evaluation today. But here's the hard truth. Courts aren't moved by last-minute regret. The judge has already heard his story, and what matters isn't what he could do now, but what he failed to do before. This is the emotional peak, the moment when the human side of justice meets its limits. The judge isn't cruel, he's consistent. And consistency means that when rules are broken, consequences follow. The gavel might as well be a mirror, reflecting the choices that brought him here.
At this point, I want you to become a productive member of society. I think the only way you can do that right now is that you become sort of deterrence and encouragement for other people to follow the orders of probation. So I'm going to revoke and remand you to serve your sentence. Good luck.
Wait, sir, how long is it? I came up here from, I came up from Texas all right, sir. All right. How long do I have to do?
Whatever the original sentence was. I think we went over that, didn't we?
The original sentence was 6 months. I don't know if he's got any credit for time served on that.
Yeah, that's what it is, 6 months.
Or it was for a misdemeanor. I still have to do 6 months?
Yes, sir.
All right, sir. Yeah, okay. Is there any way to like that?
It's
never mind.
time to face the consequences. That's what's happening. State versus Colton Marceau, 23 CR 300025.
Yes, sir. Can you grab my phone right there, sir?
Sure.
And there it is, 6 months in jail. not because of some conspiracy or judicial bias, but because of personal decisions stacked one after another. Damon had chances, multiple chances, and each time he chose the path of least effort. Let this case serve as a powerful reminder. Probation is a privilege, not a right. It's freedom with conditions, and ignoring those conditions is the fastest way to lose it. A good attorney could have argued for leniency, maybe negotiate another extension, but self-representation closed that door before the hearing even started.